and welcome to a Newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Hi, Richard.
Hello, Lizzie. How are you?
I'm very well, thank you. And we're here for another Newsflash episode today, this time on a Court of Appeal case from the 7th of April called White and Alder, or Alder. And it's the first Court of Appeal case that's ever dealt directly with boundary agreements and whether they bind third parties. So do you want to start with the background law around this?
Yeah, well, people forget it. We talked about it in one or two cases of late, and also on an adverse possession webinar that we did, that there is a general boundaries rule under Section 60 of the Land Registration Act of 2002, which has always been there in the land registration rules beforehand. But you can't guarantee the land registry plans exactly determine the boundary. And there's a lot of cases of going back many years. You can actually go to the you apply to the land registry under the land registration rules 117 to 123 if you're interested, to get an exact determination of the boundary. But there's lots of cases about determining how you determine the boundary in the absence of this, such as extrinsic evidence and the likes, old plans and old maps, old ordnance survey maps and so on. But one thing that's been discussed for many a year is that you can have a boundary agreement, a sort of informal boundary agreement between parties that they agree this is where the boundary line is. And the real question over the years is whether that binds the subsequent purchasers, and if they don't actually know about this agreement. The cases go back to, the first case I can think of, the first case that was in the law report, guess when?
A long time ago?
1750, from colonial America. Which was discussed, it's nice to see, an agreement from 1732 between Penn and Lord Baltimore. It was later on, it was in 1768. The boundary between Pennsylvania and Maryland was finally settled exactly and became the Mason-Dixon line because of the surveyors who settled it, which was between the North and the South, hence Dixie. In the southern states. So that's a bit of interest, don't you think?
You're looking very interesting, yeah.
And that was an agreement from 1732, a boundary agreement, which was discussed by the Court of Appeals, only briefly, but I thought it was interesting. But shall I tell you the background of facts a little bit?
Yeah, let's move on to the case in present times, just last month.
That's a bit of history, Lizzie. You'll never have it taken away from you. There was, several other American cases by all accounts, but I won't bother you with them. All took place on the edge of Chelmsford in Essex. Two neighbours. The White owned one piece of land called Willow Cottage, and Professor Alder and spouse were the neighbours, I say owned, the registered proprietors of these two properties. The neighbouring property called the Old Stores. I wonder what that was in the past. They bought the properties, both of them, within not much more of a week of one another, in November of 2005. But in October of 2005, their predecessors, White's predecessors were the Hobsons, and Alder's predecessors, the Joneses, had entered into a verbal agreement settling exactly where the boundary was, which they then repeated in writing soon afterwards. And when White and Alder purchased these properties, sort of less than a month later, they knew nothing about this boundary agreement. What then happened, you can fast forward to the spring of 2016, no one's exactly sure as to the dates of all these things, when White demolished, was going to build an extension and demolish part of the wall, which had this boundary agreement had settled as being in Alder's, title, if you like, Alder's side of the boundary, and also laid foundations on this land and put scaffolding up temporarily. And after that, for several years, they seem to have sort of stored on the land, and Alder claimed they trespassed on the land. And I think it was in 2020, that's when Alder brought a case wanting damages and injunction and to stop the trespass, and the declaration that this land was actually theirs. And that's some of the background. Shall I explain the sort of, the problems in the law?
Yes, please.
Well, I mean, basically, the first instance and the second appeal both said pretty much the same as the Court of Appeal. You can have boundary agreements between the two parties, but the question is, whether that boundary agreement binds a third-party purchaser without knowledge of it. And there'd been a case called Nielsen and Poole. It was only a High Court decision in 1969, but it seems to have been accepted, although not exactly to the point, in several subsequent Court of Appeal decisions. One was a case called Joyce and Gigoli, I expect it is, in 2004, and Haycox and Neville in 2007, which had said basically that Nielsen and Poole was correct, but only obiter. Have I told you what obiter is before?
I don't think so, no.
Well, if it's the ratio of the decision, it will be binding in the court hierarchy. It will be binding on lower courts. Obiter is persuasive, obiter dicta. About the first thing I ever learned about the law many, many years ago in 1750. They basically said that Nielsen and Poole, was correct. And Nielsen and Poole said there was, you've got to distinguish between two separate things. One is an agreement which transfers actual land, because a contract in land, well, nowadays, not at the time of Nielsen and Poole, the statute of frauds would apply and the likes, but nowadays it will have to comply with Section 2 of the Law of Property Miscellaneous Provisions Act, with a few exceptions. It has been in writing, contain all the express terms, and be signed by other parties on behalf. And also, it wouldn't bind third-party purchasers as a contract in relation to land. I think they got a bit confused here myself. If the title of the land's not registered, it has to be registered as a C4 land charge, an estate contract, a contract to create a legal estate in the future. If it is registered, the title is registered, it should be registered as a notice. They didn't say in the report, but there are a couple of cases from my teaching land law days many years ago. There's a case called Grace Reimer Investments and Weight in 1958, and another one called Webb and Pullmont, 1966, which said that it could still bind as an overriding interest, a contract in relation to land and registered land, if you're also in actual occupation. You've got overriding interest, the rights of people in actual occupation. What they said on the other hand in Nielsen and Poole, that if it's a sort of just an agreement, this is where the boundary is, you're not actually transferring land. Unfortunately, there'd been a case back in 2021, not so long ago, called Gibson and New, which had said otherwise and seemed to go against that, and has caused a few issues ever since this last 4 years. And that's basically what the Court of Appeal had to decide. And shall I tell you what they decide, or shall I hold you in suspense until next week?
I think it's only fair if we go through that now.
As with the two lower courts, the Court of Appeal, I think it's got to be the right decision, said, you're not actually transferring land, you're just agreeing between the parties where the boundary should be. And that binds third-party purchasers, even if they don't know about it. And so they said, but basically, the lower courts basically said that the Gibson and New was, again, just obiter. It wasn't the reason for the decision and wouldn't be binding. I got my doubts about that, actually. And it's been put to one side now, and presumably that settles the issue. You can have boundary agreements that bind third-party purchasers between the two parties.
So what's the significance of this judgment then?
One thing I think you might actually think about is whether you need to make inquiries as to boundary agreements and the likes. If you're purchasing a lot of the land, you're talking about, minuscule amounts of land. And there is a lot of confusion with a few other things that we've been discussing of late, like whether you can claim adverse possession in registered land after 10 years, which they sort of brushed aside here. We did a case on encroachment not so long ago, albeit a first-tier tribunal case called McGee, if you remember. Was it leasehold reversions, Harrogate? Freehold reversions, I should say, Harrogate. They seem to, in estoppel claims, they seem to kind of, all of them to some extent, blend together. But boundary agreements should be binding on third-party purchasers, even if they have no knowledge of them. And that's it.
Thanks very much, Richard. It's got me thinking. I think we should start doing cliffhangers. They'd be good for the download figures.
Yeah, next week.
Thanks very much. Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.